Mr. Radcliffe.
My Lord, I appear on behalf of the appellant in this matter. My learned friends, Mr. Mallonitz, King's Counsel, and Mr. Aikins appear on behalf of the respondent. There is a transcript being taken in this case, my lords. I don't know what the practice of the court is and whether they wish to be reminded to take a break or just to press on. Raise it at the outset.
The normal practice in this court is just to keep going, and I don't think there's a good reason to depart from that.
Indeed. I'm conscious that all of you will have read both judgment and skeleton arguments in this case, and that I may be consequently brief in opening in setting out the context for my submissions on this appeal. It's a trademark passing off dispute. It had two aspects to it: a challenge to the defendant's trademark and a claim for infringement and passing off against that defendant. For both, the claimant relied on a registration for the word VETSURE, registered, among other things, for insurance in Class 36, and the goodwill it had built up and that was associated with that sign for pet insurance. The defendant's trademark is PETSURE, applied for on the 21st of October 2020 and registered in Class 36 for pet insurance, used for the defendant's business in pet insurance from July 2021 onwards. Now, first instance, in relation to the trademark dispute, the claimants raised the provisions of the Trademarks Act that are concerned with confusion, but also those concerned with damage to reputation. There's no permission to appeal against the findings in relation to the latter. That's sections 5.3 and 10.3, so I shall say no more about them.
Can I just voice one gripe?
Yes,
Which isn't restricted to this case, but applies in other sorts of cases. I've had it most recently in a family case where the specialists assume that every member of the court knows intimately the statutory provisions and therefore doesn't include them in the bundle, when they obviously ought to be in the bundle. So we don't have, I mean, I can see the statutory provisions in the judgment apart from anywhere else, but for the future, can they please be in the bundle?
My Lord is quite right, and noted. But I take it from what my Lord has said that despite our failing, my Lord has corrected it by looking at the statutory provisions in this particular case.
Yes.
Certainly, I won't assume, apart from some people on the court's bench, any knowledge, and if I have done so, and I ought, in fact, through reversing course and going into it in a bit more detail, my Lord, I know, will draw that to my attention. When I speak of sections 5.3 and 10.3, those are the ones where the prerequisite is the existence of reputation in the trademark for particular services and goods, and it is that reputation that is then to be tested to see if there is any damage in relation to it. As I say, no permission to appeal about them, so I shall say no more, save to foreshadow that it will be necessary to speak of the issue of the finding of the judge that the claimant's mark had a reputation for pet insurance under those sections, because we say it has relevance to some of the decisions that were made in the context of sections 5.2 and 10.2, those being the sections that deal with confusion. Again, my Lord, I will speak without delving into the differences between 5.2 and 10.2, because...
But it doesn't matter in this case, because there's only one question, and the question is PETSURE confusingly similar to VETSURE for pet insurance? And the difference in the statutory tests is immaterial, although there is, as you've pointed out, a difference in dates. Nobody suggests there's any difference in the reputation of the trademark at the two dates. Therefore, it all collapses into one question, and nobody suggests that there's a different result on passing off either.
My Lord is quite right. I'm simply responding to my Lord's suggestion that I ought not to assume that everybody has the same clarity as to the state of affairs. My Lord said that there was no difference between section 5.2 and 10.2 in certain respects. One other respect, obviously, is that it can make a difference, not just the date, but also the circumstances of use. But again, my Lord, that nothing turns on that.
This is not a case where anybody's relying on context as negativing a likelihood of confusion that otherwise might exist.
Right. Another thing that is common between those two sections is the touchstone of the assessment being the average consumer. And here it is, and was certainly by the time of trial, common ground that the average consumer of pet insurance is the ordinary consumer who pays no special level of attention in the selection of the services. And my Lords may well know that there's been a lot of debate about the nature of the average consumer. It's not a person so much as it is a test. It's a level of attention that's being paid. The issue, therefore, was, as my Lord Justice Arnold says, whether there was a real likelihood of confusion if, in relation to identical services, the signs VETSURE and PETSURE were used. Now, the judge concluded that there was not, nor indeed any likelihood of deception, that last being a reference to the test in passing off. And we submit to you that that decision is born of error. Key among them is the judge's comparison of the conceptual meaning of the marks VETSURE and PETSURE. He held that they were conceptually different. He did so because he compared part of the signs, VET and PET, and held these to refer to different concepts, as they do. But we say what he was required to compare was the meaning of the signs as a whole, VETSURE and PETSURE, and these are not conceptually different, but similar, because both reference insurance for the payment of vet bills for the treatment of pets. It was a material error because the conceptual difference was used to trump a situation in which every other factor highlighted by the statute and the authorities, the visual and oral similarity of the signs, the identity of the services, the existence of a reputation, all pointed towards a finding that there was a real likelihood of confusion. And that, my lords, is ground 2 in my grounds of appeal. That is, we say, enough. And though I shall go on to explore the point in more detail, you have the essence of the appeal in what I have just said. Now, there were other important errors by the judge. We say he gave inadequate credit, or indeed no credit, for the reputation of the VETSURE sign in his analysis. There was no consideration, we say, of enhanced distinctiveness through use, given when he was considering section 5.2, and it should have been. And when it came to section 10.2, his approach, we submit, was incoherent, because under that heading, he held there was no enhanced distinctiveness through use for pet insurance, even though he had held that the sign had a reputation sufficient to warrant protection under section 5.3. And that will be ground 3 of the appeal. Now, those errors find their manifestation in his approach to the likelihood of confusion, and there we say he failed to give due effect to the concept of imperfect recollection. And we say he mixed and blurred issues of conceptual comparison, descriptiveness and distinctiveness acquired through use. That, my lords, is going to be my ground 4. My lords, we do also say that his approach to the evidence of confusion was erroneous. Most obviously, when he holds that an absence of such evidence is fatal to a passing off claim, we say that is not the law. But we also say that his assessment of the evidence wrongly emphasised quantity as a test, and what he should have been doing is using the evidence to test the propositions he had advanced as to the understanding of the average consumer, and if he had done so, he would have seen that the evidence was contrary to those propositions, and that will be my ground 14. Now, my lords know that there are other grounds. I shall pick them up as I go along. But let me say one thing briefly about the test on appeal. My lords, of course, more than familiar with the nature of an appeal such as this. It's not enough to present you simply with a judgment whose conclusion we ask you to disagree with. I must show you that the conclusion under appeal stems from an error, whether of principle or of judgment. And as I say, in this case, we submit that the judge made several such errors. The nature of the error here is not in the failure to take into account something that should have been taken into account, but a failure to evaluate that fact adequately and to take proper account of it. You can, for example, recognise that you should perform a conceptual comparison, but then err in that comparison by breaking down the mark into its component parts and comparing only those parts, not the whole. You can know that you should take into account enhanced distinctive character under section 10.2, but then we say inexplicably, and not do so in relation to section 5.2. You can recognise that you need to consider recognition of the public of a sign, but then err by not giving to the consequences of holding that the mark has enough public recognition to qualify the special and stronger form of protection under section 5.3, that same effect when you're considering enhanced distinctiveness under section 10.2. Now, my lords, in my skeleton argument, I have set out where we say the judge erred in the order in which those errors appeared in the judgment. But I'm going to take them orally, if I may, in a different order. Starting with that one that I say is the most significant and proceeding, I trust you will find in a logical order from there. I want to begin with the judge's comparison of the signs, and specifically with conceptual comparison. That's ground 2. This is an error that we say affected all that followed. My plan for my submissions is to show you what the judge concluded on the conceptual comparison, then to explain why we say his conclusion is wrong and contrary to authority, and then to show you how the erroneous conclusion was central to the assessment of the likelihood of confusion under 5.2 and 10.2. My lords, may I ask you then to take up the judgment, which is in the core bundle behind tab 6. The judge begins his judgment by setting out the context, and at page 71 he explains that this was a case in the shorter trial scheme. You see that in paragraphs 14 to 18. We say one may detect in what is said in those paragraphs a degree of frustration, sense that he feels a pint is being forced into a half-pint pot, and that he is being asked to do too much of the work unaided. The judge then goes on to discuss the evidence that was put before him, and at page 75 in paragraph 42, he turns to the claimant's business, the means by which it is encountered by consumers, and the matters that will later form the basis for his finding that it did have a reputation for pet insurance, such as the number of policies and premiums and the awards that it had won. He then proceeds to set out the law from page 79 of the bundle onwards. And my lords, and I know in particular my Lord Justice Arnold, whose judgments are here being quoted, will be very familiar with the principles that are set out there. The need, as one sees on page 80 in the recitation from Sazerac Brands, the need to consider the mark as a whole, the requirement to consider imperfect recollection, the balance that is to be struck in the assessment of confusion between the level of similarity of the signs and the level of similarity of the services, the way that one can set off the other, and the increased likelihood of confusion where signs have a distinctive character either inherently or through their use. Mr. Karet then goes on to identify the average consumer, and at paragraph 69 on page 85 comes to section 5.2, validity, where he recites first the arguments of the party. His analysis of the likelihood of confusion begins at paragraph 81, and I know my lords will have read those paragraphs with care. For my present purpose, the paragraphs to concentrate on are 83 and 84. What we say emerges from paragraphs 83 and 84 is that the judge has concluded that the two signs in issue are conceptually different. As he says at 83, the marks are not conceptually similar. Each refers to a different descriptive concept. And at 84, he says the marks are for different concepts. As we see at 84, this finding of conceptual dissimilarity is a crucial part of his conclusion that there is no likelihood of confusion. Now, my lords, before I go further, I want to show you some of the other passages in the judgment, so that you can be confident that you've seen the whole picture of the judge's thinking on the meaning of the signs and their relationships, for precisely the reason my Lord Justice Arnold articulated at the outset, that there is this connection between all of the headings. First thing that the judge goes on to do is to deal with section 5.3, and that you find at page 88 of the bundle and at paragraph 93. He accepts there that the VETSURE mark has the required reputation but qualifies it, explaining the mark indicates that it is for a service relating to vets. At 95, he explains that the link required under section 5.3 does not require confusion but something lesser, and in his judgment even that lesser requirement will not be found here. PETSURE will not call to mind VETSURE even when used in relation to identical services. He then turns to section 5.4, and that you find at page 89. And here he is addressing the view of whether passing off supports the challenge to the defendant's mark, Section 5.4, my lord, being that heading that allows you to rely on unregistered rights, copyright, but in this case, passing off. And his judgment here is given at paragraph 103 in what we say are entirely conclusory terms. Nothing is added here to explain why he has come to this conclusion. And my lords will have seen that we do say at ground 8 of our grounds of appeal that there was a failure to give reasons, even to the extent of saying that they are imported from other areas. Now, we may guess that the reasons are those that supported his finding that there was no confusion nor even any prospect of a link between the signs, but it will, of course, be a guess. Nothing is said expressly. The judge then turns to infringement and to section 10.2. And his first judgment that I draw your attention to is to be found on page 91, paragraph 110. Here he holds that there is no enhanced distinctive character for the mark. He says in the final sentence of that paragraph, the claimant also relies on positive customer reviews, but these do not, in my view, establish the reputation in the circumstances of the use made of the mark. Now, my lords will know from having seen my skeleton in the grounds that we say there is a tension here, an inconsistency that manifests itself in the judgment. There is reputation, we saw that under section 5.3, then there isn't. And now that's my ground 3. I'm going to return to it under that heading, but I draw your attention to these paragraphs as we're going through it. His next step is to consider the evidence of actual confusion, and again I'm going to return to that, if I may, at the end. For present purposes, I say we can turn on to page 101 in the bundle and paragraphs 178 and 179, where he gives his conclusion on section 10.2. My lords see at 178 that there is an observation about the challenges of enforcing descriptive marks and the identification of this as such a case. It won't surprise you to learn that my client doesn't consider that it is attempting to obtain a monopoly over ordinary descriptive words. This is not an attempt to monopolise VET or PET or insurance. This dispute is over specific signs, VETSURE and PETSURE. These have descriptive connotations, but they are not ordinary descriptive words, as was the case in the authority that the judge points to, where the European and the economists were fighting over the use of the word European. Now, the judge seems to have in mind, in making the observation he does, the breakdown of the signs that he performed, as we saw under the discussion at 5.2. Again, we say it is indicative that he is not thinking of the whole signs, but of their parts. Now, at 179, my lords, there is a statement that the evidence of actual confusion is consistent with that. That here presumably being his conclusion that there is no likelihood of confusion, including the statement that the presence of actual confusion does not show a likelihood of confusion. Again, I want to return to that and whether it is itself a sign of confusion on the part of the judge. But for present purposes, my aim is only to show you that the section 10.2 analysis does not expand on or clarify the consideration of the comparison of the signs that he had carried out under section 5.2. So too is the position when he comes to section 10.3, and you will see that that is dealt with very briefly from the bottom of 101 over to 102, and so too is the case for passing off, which is dealt with again very briefly over to page 103. The conclusion we say on 10.3 is again simply conclusory, and that in relation to passing off we say similarly so. If my lords look at paragraph 189 on page 103, we say that you can see the judge's view has moved on from what he had said at 179. There he had said that there was evidence of actual confusion, but it didn't show a likelihood of confusion. Now in 189 it's gone further. There is no evidence of confusion or deception as to origin, or any likelihood. And my lords will know that I picked up on this apparent change of position in what we say at paragraph 40 of my skeleton under ground 13. And I ask you, since you have it open here, also to note that he says more than that. Here he says the absence of evidence of confusion or its likelihood is fatal to a claim of passing off. And that appears, we say, to be a general proposition rather than specific to this case, but however it is passed, we say that is a statement that is not the law. And again, I will return to that briefly when I deal with passing off. But that review, I hope, my lords, allows me to return to paragraphs 83 and 84 on pages 86 and 87 of the bundle. As we read the paragraphs starting at 82 and running through to 84, the basis for his assessment of conceptual difference expressed in paragraphs 83 and 84 is that although the sure element will be understood to reference a common idea, insurance services, VET and PET are different concepts, and so in combination with sure will be understood to reference different things. And we say that conclusion is wrong. A VET and a PET are different things. That doesn't mean they aren't related. They have a common referent, animals. Yes, one is a reference to the treating party and the other to their relationship to humans, but in both cases they are only relevant here as having in common the animal reference, and moreover and connectedly, that a VET and a PET are different doesn't make the overall concept of VETSURE and PETSURE different. That is the point that we are making in my skeleton argument at paragraph 8. Once you have acknowledged that the conceptual context is insurance, we say you must ask what the VET and PET qualifier indicates conceptually, and an obvious answer is that it is insurance for your pet to pay for your vet's bills. Now, had the judge said that the two signs were merely conceptually similar, I would have had a different task before you. But that he says they are different is, and we say can only be, a consequence of error. He has focused on the specific differences of the first parts, and not considered how they are generally related. He has broken down the signs into elements and not considered how the conceptual message is conveyed as a composite component. Now, I'm keen to emphasise, my lords, for reasons that will become apparent when we look at my learned friends' arguments that are put against me, that it is necessary, that it is the central task to consider the mark as a whole and the overall conceptual message of these signs when doing the comparison that is called for.
The first judge, he does say in 83, perceiving the marks as a whole.
Yes.
So he was considering the whole.
Well, indeed, he's cited the guidance that tells you should do that. But the analysis that I put before you is designed to show you that the only possible difference can arise from not doing that by focusing on just one part of it, the VET versus the PET. Because it is only when you put them together that you understand that the overarching concept is that you're paying for some form of insurance related to. Now, in making the explanation to you that I have done, I've had to break down the elements of the signs in order to show you where the judge has gone wrong. That doesn't mean that the ultimate analysis is one in which you leave that breakdown untouched and analyse each element separately. That's what we're saying the judge has done. Gone wrong. And indeed we say it's also why it's an understandable error to make, because one is drawn into that kind of analysis in order to understand what's going on.
Yeah, and also you say that in 84, in the last sentence, he says the marks are for different concepts, and you pose the rhetorical question, well, what's the different concept?
Quite right, my lord. My lord has anticipated my next set of submissions. Yeah. Because one of the things that you note, what I say is, you can see that the error has emerged in the way we ask, or the way we suggest, by looking at the reasoning in more detail. He's expressed, as my lord points out, that the concepts of the signs are different. What does he say are the concepts of the two signs as a whole? And I think my Lord Lord Justice Arnold anticipates that my submission to you is he doesn't. What he says at 82 is that VET is a description of veterinary services and SURE will be understood to describe insurance services. He then says the VETSURE mark is thus a combination that is itself descriptive, but he doesn't say expressly what he thinks that combination describes. Now, it seems reasonable to conclude that he is taking it to describe insurance for the cost of veterinary services, which is consistent with what we then saw him say at paragraph 93, my lords will recall I took you to that, of the judgment. When it comes to the infringing mark, PETSURE, there is no express analysis of what he takes PET to describe, or what he considers the combination PETSURE to describe. At 84, there is some indication, because in the second sentence he explains that the descriptive nature of the words will have an impact on the impression made by the marks, and goes on to say the average consumer would know that descriptive terms are commonly used in this field so that vet and pet are unlikely to indicate any particular source of pet insurance. So we say, if one is to make an assumption, and it is an assumption, there is no express analysis, a reasonable assumption is that he takes PETSURE to indicate insurance services for pets. And immediately begs the question, what are they being insured against? And the obvious answer, an answer consistent with the evidence in this case, is it's the cost of veterinary services for those pets.
That wouldn't be the entirety though, would it? So presumably, if you have a expensive breeder pet, you may insure against the cost of their death.
You might do.
And replacing them.
You might do, my lord. And indeed, what my learned friend says in his skeleton argument is maybe that's what the judge meant. But we say part of the problem here is that the judge hasn't set out exactly what he meant. And if it is part of what he meant, well, that doesn't help us, because part of the conceptual message, even on that analysis, would be of similarity, not difference. So we submit to you that, in fact, taken as a whole, VETSURE and PETSURE, if they are having any descriptive allusion, which they do, are descriptive not of different concepts, but the same concept, insurance for the cost of veterinary treatment for pets, or at least that is part of the concept they convey. And we do say it is significant that the judge fell into error, or how he fell into error, that this passage in the judgment never sets out what the concept of the actual signs is, only of parts taken in isolation. It is significant that the contrast identified expressly is only between part of the signs when taken in isolation, and it is significant that that contrast, as identified, breaks down when one considers the analysis of the whole, and yet the analysis of the whole is never set out. And in their skeleton argument, my learned friends, starting at paragraph 35, pick up on a choice of word in my own skeleton argument, where I talk about complementary concepts. They say there is no issue of complementarity in the context of comparison of signs, as opposed to that issue as it arises when one is comparing the goods and services. And my lords, the first point to make here is that I'm simply using the word complementary in the same way that it is talked about in Sabel, analogous concepts. I'm not attempting here to introduce that same test that is to be found in the context of comparison of goods and services. In Sabel and Puma, which was one of the judgments of the Court of Justice very early on, which discussed conceptual messages, at paragraph 24, they spoke of whether there was analogous semantic concepts. By speaking of whether there could be analogies, they are necessarily speaking in terms of whether there is some form of relationship between the concepts, not identity between the concepts.
And this isn't an authority in the bundle.
It isn't because, my lord, it's so uncontroversial.
Well known to specialists.
Well, again, my lord, I apologise for treating it as such. The proposition is simply that in Sabel, at that paragraph, they explain what they mean by conceptual comparison, and it is of analogous semantic concepts. Now, my lord raises the point that attempting to meet the guidance that we should put in no more than the authorities on which there is contention. I debated with my learned friends Junior as to which authorities ought to go into the bundle, and as I say, Sabel was one of those that did not make the cut because it was so well established.
And just talking around it for a moment, as a non-specialist,
Yes.
We're concerned with A, similarity, B, likelihood of confusion. And as I understand it, what the judge is deploying the conceptual similarity point in relation to is not really similarity, it's likelihood of confusion.
Well, my lord, this is where we say one of the errors in the judge's approach arises. I'm going to come to it, but if I may pick it up now. It is a requirement for this form of infringement that you have similar signs and similar goods and services. In consequence, the question of similarity is a liminal issue. If you don't have similarity, who cares whether there's confusion under this heading?
Yes.
For that reason, repeatedly in the judgments, particularly of the Court of Justice, they have said you have to assess that question first, because it is a liminal question. And as I would like to expand on in a moment, what I will say is that the judge muddied those waters by mixing up his question of the conceptual comparison with the subsequent question of the likelihood of confusion.
Well, reading the judgment, I would infer that there was no dispute before the judge that the mark and the sign were similar. So the threshold was passed and the question was purely one of likelihood of confusion.
Well, it's right to say, my lord, that the liminal question did not arise.
Yeah.
I think it would be fair to say, however, that there was debate, particularly over the question of the conceptual comparison of the marks. It might be that I can give you chapter and verse, my lord, on that very point, although I'm not certain that it's particularly determinative, because we have the claimant's closing submissions for the trial, in the supplemental bundle. And if one turns to page 191 in the supplemental bundle, you will be in the submissions of the claimant in closing with, and what they've done is update their opening submissions with further points in red in closing in a common way. If you look at 191, you can see here that we're in a paragraph that's dealing with the comparison of the marks. And at sub C, they're dealing with the conceptual one. The submission made by the claimant is that they are conceptually identical. But you can see from what is being argued afterwards that at least the understanding was that there was in fact some conceptual dissonance or counteraction in the argument made by the defendants. So to that extent, I think, my lord, it's right to say that this particular issue was live.
Well, yes, but what that demonstrates is exactly what one would expect. Namely, the argument was not, there is no similarity at all, and therefore you can stop the analysis
Quite
there.
right.
The argument from the defendant's side was, yes, of course there's some similarity, that's obvious, at least on visual and oral level.
Yep.
But the argument was one of conceptual counteraction.
Yes.
And we know from the case law that in legal terms that's a permissible argument.
Quite right, madam. Quite right.
But it goes to likelihood of confusion, not the threshold question.
That's quite right, my lord. The point I'm going to make, or expand on in a bit more detail, is that nonetheless that question is a preliminary question. First you make the comparison, you come to a conclusion, then you ask yourself, well, how does that play out in the likelihood of confusion? And I think that will become more apparent when I address the issue of the descriptiveness element of the marks.
Just talking around it for a moment longer. So we come to the question of conceptual similarity, if nowhere else, in the context of likelihood of confusion.
Certainly it's relevant to that context, yes.
Certainly relevant to that context. And coming to this as a non-specialist, I sort of feel that the fact that you're looking to likelihood of confusion ought to cast light on what sort of conceptual similarity or dissimilarity would matter. I mean, the ultimate question is likelihood of confusion rather than conceptual similarity, presumably.
Yes, ma'am.
So, in that context, I mean, I think this is consistent with what you're saying. You say, does the average consumer think, well, what PETSURE is referring to must be a different thing from what the other one is referring to. And one might think, well, the average consumer would think, well, they're both something to do with insurance for pets.
I say that's exactly what they would think. And in the context of the likelihood of confusion, by which time you are also not only entitled to, but supposed to take into account the context of the services in relation to which these are being used, the fact that the services in question are pet insurance is plainly relevant. It's relevant on the one hand because my learned friend says, well, got to be careful there because now the descriptive allusion is to the very services in question. I would say, actually, that tells you that that's the concept they're going to have in mind, but also in this particular case, particularly when it comes to imperfect recollection, it is going to lead them to a situation in which those visual and oral similarities become much more important. And I'll explain that, if I may, in a moment. I was just dealing with the question of what conceptual similarity meant, and we had talked about Sabel and this idea of analogous semantic concepts. The reason I'm going into this in some detail is my learned friend's taking it as a big point in his skeleton argument. At least I think he takes it as a big point. I just wanted to finish it off.
Yes.
And I was explaining that we had tried to keep within the 10 authorities that the court asks, and so there'd been a debate, what should go in, what should come out, and one of the things that came out was a 2023 decision of the General Court of the European Union in relation to the signs camel crown and camel active. And in holding that those two signs were conceptually similar to at least an average degree, the General Court made clear that conceptual similarity may arise as a result of common elements that form part of the whole and as a consequence of related concepts. Now, I say unsurprisingly, that proposition was not contested. We didn't need to put the authority in because it's no more than a manifestation of the point made in Sabel that you're looking for analogous semantic concepts. But I do say that if that proposition is conceded, then one concedes the rationale under which we say that Mr. Karet should have found that these two signs were at least similar. And that's the point that I'm making in my paragraph 8 when I speak of complementarity. Now, my Lord, even if I had intended to speak of complementarity in the same terms that one encounters it in relation to goods or services, I say that would have been permissible, and the case that my learned friend cites does not support his position to the contrary. Can I deal with that quite briefly? It's in the authorities bundle at tab 6. It's page 152. If my Lord's looking at it. To foreshadow where I'm going to go, my Lords, we say this isn't a helpful authority. It's a dispute on its facts in which the central error identified by the General Court was that the initial comparison, a conceptual comparison, had not been between the two signs as such, but had rather proceeded first by abstracting out a concept from each sign and then comparing the concepts of those abstractions out. What it is not doing is holding that complementarity in that good sense is inapplicable to the conceptual comparison. Now, my Lords can see the two signs in issue at pages 156 and 157 in the bundle. The mark that was applied for is at page 156, and the mark that was used to oppose it is at page 157. And the decision deals at length with the visual comparison, concluding at page 166 in the bundle in paragraph 52. Perhaps I could just invite my Lords to look at that quickly.
Sorry, I think I've lost
My fault, my Lord. Page 166.
Yes.
Paragraph 52. This is where they're giving their conclusion on the visual comparison.
Yes.
They then turn to the conceptual comparison at paragraph 55 over the page on 167. And just to summarise, Apple had argued that both logos represented fruits and that could lead to conceptual similarity. The EU IPO, that's the European body that registers trademarks and had considered the issue first, had agreed with them, when the opposition was raised. On appeal to the General Court disagreed with the assessment, and it identifies a number of differences. And then at paragraph 66 on page 169, they note, I'm summarising the paragraph here, that commonalities might exist and be relevant even if the base object was different. But on the facts here, they were not such as to render them similar. And in particular, and here we see this at 69 over the page, the General Court considered that the consumer would recognise specific concepts, a pear with a stem, an apple with a leaf and a bite taken out of it. They would not accordingly think of them at the conceptual level of fruit. And as explained at 70, they say the Board of Appeal had erred by taking the concepts of pear and apple and considering these actual objects and comparing them rather than comparing the signs. Now the paragraph that my learned friend points to is at 76 on page 171. Again, could I ask my lords to quickly read it? So the General Court is first explaining the concept of complementarity in the context of goods there, as I should probably have started there earlier. I apologise for not doing so. But what they then go on to say is, so it's not easily transposable. They don't say that it isn't possible, but what it objects to is that there are comparisons on the facts of this case that are not concerned with the signs themselves, but with goods equivalent to an abstraction of the signs. In other words, they are importing the error that was identified at 70. But as a proposition that it can't be a helpful analysis in any case, we say this is not authority for that. It is simply a decision on the facts. To the contrary, it's saying you can do it, but it might be difficult to do. And my learned friends have also cited the Advocate General's opinion on the attempted appeal to the Court of Justice, but I'm not going to take you to that. It merely confirms that the Advocate General is of the view that the General Court got the law right in its judgment. In other words, my lord, for two reasons I say this case doesn't help my learned friend. One, we're not talking about the kind of complementarity issues that are concerned with here. We're talking about analogous semantic concepts. In any event, even if I had been doing so, and it was thought that that was what ought to have been done, we say it's permissible. The next point that my learned friends make, my lords, is the one I think that was foreshadowed by my lord. It's at 37 of their skeleton, and it's that VETSURE may indicate insurance for vets themselves, such as professional indemnity insurance. And I have, of course, already addressed that in response to the question that was raised. We do say implicit in raising the argument is an acknowledgement that among the sign's conceptual meanings is precisely the one we point to, namely insurance for the cost of vet treatments of pets. But in raising it as a possibility, without being able to say that's definitely what happened, it only serves to highlight that the judge has not been expressed as to the conceptual meaning of the sign as a whole, despite the central role to which the conceptual comparison is given by the judge, and despite the fact that it's very clear you are required to consider the sign as a whole. I should pause there. Again, I'm making an assumption here. My Lord Justice Arnold knows that there are circumstances in which one can isolate out elements. No one suggests that they arose in this particular case. So for completeness, if you see in any of the authorities a suggestion you can narrow down to a small part, you can do, but not here and not in general. Had the judge ruled that VETSURE would be understood to mean only professional indemnity insurance or something along those lines, then naturally my argument on this appeal would have been different, but he didn't. He isolated, as we say, the vet and pet elements and the difference he saw there. He didn't consider the conceptual messages of the signs as a whole. The next point made at paragraph 38 of my learned friend's skeleton argument is to offer up other alternatives where it is said an argument of conceptual similarity might arise. These are all hypothetical alternatives that are not before the court or before the judge. They appear to be intended to suggest that the argument I'm now advancing to you operates at a level of generality that would encompass any reference to an animal in the context of insurance. In other words, it's a question of degree, the conceptual comparison in every case. But more importantly, in this particular judgment, the conclusion of Mr. Karet is not a nuanced one, it is binary. He does not say there is some conceptual similarity or there's some conceptual similarity in relation to some meanings of the sign. He says they are different. And that is the conclusion that we submit is unsustainable and born of error. My learned friend's point here at paragraph 38 is also a point about conceptual comparison. And that is, of course, but one aspect of the comparison of the signs. The others, visual and oral, here concern, in this particular case, two highly visually, orally and similar signs. The issue of the likelihood of confusion on the claimant's case does not turn on the conceptual comparison alone, it turns on the overall similarity. And the point made by my learned friend in paragraph 38 simply doesn't address that. The point they make at 39 is something I want to draw attention to, because we say it is in fact a point against them, and one manifestation of how we say, at least, the judge's error bites on the ultimate question. And my lords, it would be helpful just to make sure you know what I speak of when I say the point they make at paragraph 39. That's in the core bundle, tab 3, page 45. So, my lords, here my learned friend is drawing attention to the idea that the conceptual similarities are in relation to concepts that are elusive of the services in question. And he points out an authority that says descriptiveness downgrades the role of conceptual similarity in the likelihood of confusion. And we make the following points in relation to this issue. The first is that the judge in this case is not applying the reasoning of Mr. Alexander that is set out at paragraph 39 of my learned friend's skeleton. Mr. Alexander is saying that a conceptual similarity is less significant where it is a concept descriptive of the services in question, less significant to the finding of a likelihood of confusion, I should say. In other words, conceptual similarity may be of less help to you in such cases. But as my lords have seen from paragraph 84 of the judgment, Mr. Karet thinks both that the concepts are descriptive and that this is very significant for the likelihood of confusion because the marks are for different concepts. In other words, that conceptual difference is hurting, not helping the infringement case. But for that to be correct, for the conceptual comparison to hurt the infringement case, the starting point is that there is a conceptual difference, and you know, my lords, we say that that was an error to hold it so. If it is an error to hold it so, and in fact they're similar, then you simply have a proposition that the conceptual similarity is of limited help to the party arguing for a real risk of a likelihood of confusion. Well, so be it, my lords. In that case, one is left here with the visual and oral similarity of these signs, at the high level we say exists, used in relation to identical services, and benefiting, in our submission, from an enhanced distinctive character for the earlier sign. All of the factors point only in one direction, the finding of a real risk of a likelihood of confusion. That is why we say the judge's error in assessment of conceptual difference is so significant, because it is the basis on which he concludes there is no likelihood of confusion in the face of factors that all otherwise point in the opposite direction. It's in this context, my lords, that I draw attention to what we say is another absence in the judge's analysis of the role of these descriptive connotations of the sign, which is any consideration of how they are being used. And that is not as a description, but as an indication of origin. That's the point we make at paragraph 11 of our appeal skeleton, by reference to a decision of Mr. Caddick, King's Counsel, in the Musmatch case at first instance. My lords, can I very quickly show you that? It's in the second of the two authorities bundles. It's page 358. My Lord Justice Arnold is of course very familiar with it because he considered the appeal from it. And I wanted to take you to this section here because paragraph 90, Mr. Caddick has recited those passages from the judgment of Mr. Alexander dealing with the effect of descriptiveness, and at 91 he has made the point about the issues that can arise with marks that have descriptive connotations. And one of the things he says there is that a finding of a likelihood of confusion may well be appropriate where the average consumer recognises that the common elements, whilst capable of being used descriptively, is in fact being used distinctively as a badge of origin. And we say that is an important qualification, and one ought to have looked in the judgment for some recognition of that, but we say it's not to be found. It won't surprise you to learn that I shall pick up on that when I turn to ground 14 and the consideration of the evidence. We also submit in this context that the judge erred in the paragraphs we've been looking at by eliding the questions of conceptual comparison, descriptiveness, and the likelihood of confusion. And in a sense, I've already touched on this in response to my Lord Justice Arnold's questions. We do say that he should have kept more clearly distinct the initial stage of conceptual comparison. First, because it's right to do so as a matter of the process, the liminal issue. But second, and for my purposes much more significantly, because the elision muddies the analysis. It leads one to fail to apply the principles we have seen set out that require assessment of the sign as a whole and consideration of imperfect recollection. And it's that topic that I'd like to expand on now. The judge's premise is that the conceptual comparison negates the likelihood of confusion. But for it to operate, the average consumer must notice and have in mind that different first letter V versus P. Now we say some may, but others, having regard to the requirement to keep in mind imperfect recollection, will not. They'll be uncertain as to the first letter. And what they will recall is that the conceptual context is pet insurance. After all, that's the services they're dealing with. And the obvious example of when insurance is relevant to pets, we say, is when paying the vet bill. Or they may recall that the conceptual context is insurance for veterinary services, and the obvious example of when that insurance is relevant is when paying for your pet's medical bills. And for such people, therefore, we say that the conceptual message will generate confusion, not dispel it. In other words, the conceptual similarity will either make no difference, or we do say in this case, more likely, it will weigh with those for whom imperfect recollection means that they are unsure if it's VETSURE or PETSURE. It will make them think that the two are in fact the same because of the other similarities, visual and oral, and their knowledge of the reputation of VETSURE, which they know of as a company that offers the exact services they're looking at the sign in the context of. The judge's conclusion, we say, precludes that possibility. It precludes the kind of imperfect recollection that the authorities require the judge to consider. That's the point that we make in paragraphs 15 and 17 of my skeleton argument on appeal. And again, I say you'll see that manifest itself in the evidence. Now, my lords will note that I mentioned the reputation of VETSURE in my submission to you just now. And one of the points that I make on appeal at paragraph 16 of my skeleton, which can be found in the core bundle at page 27, but I ask you just briefly to turn it up. is about the significance of considering those consumers for whom the earlier sign has a reputation. And in that context, I've cited two authorities. Again, neither of them were contentious. The observation that I'm referring to in Aveda Corporation is one of my Lord Justice Arnold's. In fact, it's cited in other authorities, and without any disrespect to my Lord Justice Arnold, it is a proposition of no more than common sense. The human eye has a well-known tendency to see what it expects to see, and the human ear to hear what it expects to hear. Now, my learned friend's skeleton at paragraph 81 tries to treat that observation as only about inherently distinctive marks. We say it's an observation about the concept of imperfect recollection and how reputation in particular plays on that. The consumer is going to recall the mark they have heard of. They're particularly likely to do so, we submit, if the mark they see so strongly resembles that mark and appears to evoke the same concept as that mark. Confusion, we say, will then arise because they will see or hear what they expect to see or hear, namely the mark with a reputation. The judge's position, again, precludes that possibility because it assumes a perfect awareness. It must do so because the judge is assuming that the distinction between vet and pet is operative, and that's the point that I'm making in paragraph 15 of my skeleton. Indeed, we go so far as to say he expressly excludes that possibility because of what he says at paragraph 84, that the average consumer will know that vet and pet, this is the middle sentence, are unlikely to indicate any particular source of pet insurance. But for those consumers with whom the claimant has a reputation, that is not so. They know that VETSURE means the company they've dealt with for pet insurance. My lords can see I've moved on from ground 2 to ground 4 in the course of this discussion. And that's inevitable because I need to show you not only that there was an error in the comparison of marks, ground 2, but also how that error materially fed into the ultimate question, that's ground 4. Our submission is that the judge went wrong in his assessment of the likelihood of confusion. His analysis was simply not rigorous enough, with all due respect to the judge. And my learned friends say in their skeleton at 79 that the judge didn't fall into error. They say you can see that the judge had in mind, for example, the issue of imperfect recollection because he mentions it in 2 paragraphs, and they cite 79 and 87 of the judgment. My lords, paragraph 79 is simply the recitation of authority and the now standard authorities. And our argument is to you is certainly not that the judge failed to recite the authorities indicating you needed to consider imperfect recollection. It's that he erred in his application of the principle. As to my learned friend's reference to paragraph 87, we say that, in fact, one of the ways in which the erroneous analysis manifests itself is in the passage at paragraph 87 of the judgment, which you will find on page 87 of the core bundle. Now, this is apparently the analysis of imperfect recollection, but we say it contains no consideration of how imperfect recollection might operate, nor does it contain any consideration of how the visual, oral and conceptual similarities might operate in circumstances of imperfect recollection. What it instead contains is a statement of relative confusion. VETSURE and PETSURE, it is said, are no more likely to be confused than any other descriptive and elusive names. And we submit that that is a comparison that reveals his analysis has reduced down to solely conceptual comparison, because it is there that he has found the descriptiveness. And in saying that VETSURE and PETSURE are no more likely to be confused than other marks with descriptive connotations, and it may interest you, my lords, to see at paragraph 52 that the judge has set out an overview of the market where he references insurers using pets in their name. we say, in saying that VETSURE and PETSURE are no more likely to be confused than other marks with descriptive connotations, such as those in 52, he must be excluding from consideration the degree of visual and oral similarity between these two particular signs. It's simply not plausible to dismiss VETSURE and PETSURE as no more likely to be confused in circumstances of imperfect recollection as signs such as healthy pets and VETSURE, different visually and orally from VETSURE, or VETSURE and VETS Medicover as no less likely to be confused. Only by setting aside the fact that the two signs in issue are very close visually and orally could you make such a statement. And that, we say, is why, in fact, paragraph 87 fails as an analysis of imperfect recollection, but succeeds as an indication of why the judge has steered himself incorrectly because of his approach to conceptual comparison. It's in that context, my lords, I ought briefly to mention ground one. We do say that visually and orally VETSURE and PETSURE are properly described as highly similar. The judge does acknowledge that similarity, but not the degree that I urge upon you. I have to accept, my lords, that if that point stood alone as a basis for appeal, I might struggle on the ground that the distinction between similar and highly similar is the sort of nuanced judgment inapposite to an appeal. But what we do...
Just coming back, you say inapposite to an appeal. I mean, again, it only feeds through the likelihood of confusion, doesn't it? So
Yeah.
how you express yourself as to the degree of similarity is not really the issue.
That's quite right, my lord. What I'm saying is that, and by raising the question of how one characterises the degree of similarity, I'm really making the point that I've just made at paragraph 87. It's just disappeared, the question of visual and oral similarity from his analysis. It's all become about the conceptual similarity because he thinks there's a difference, we say wrongly, and he thinks that that's counteracts the likelihood of confusion. I don't want to say any more about ground one than that. My lord's quite right. It's because it feeds into ground four. And indeed, my Lord Justice Arnold, in granting permission, said, oh, look, there's a lot of grounds here. But in truth, really, all that one's trying to do is say, these are the different points at which it all feeds together. So one shouldn't confuse the fact that I've spelled it all out for my suggestion that there isn't really a fundamental problem here. And it's a fundamental problem, particularly in ground two, as it then manifests itself in other places. There is another fundamental problem, and it's ground three. Ground two, I say, as it manifests in ground four, is enough. That's the problem. Ground three is about the approach to reputation and acquired distinctiveness. The significance of the errors that we say manifest themselves under this heading are twofold. First, we say they confirm a lack of coherence in the judge's analysis, and they're part of the reason why the judge was not alert to the material errors in his assessment of the likelihood of confusion. Now, the starting point for that submission is to try to understand what the judge thought was the inherent and acquired distinctiveness of the VETSURE mark, and here we say that the judgment is in fact incoherent as to the position that the judge adopts. I have a strong point, and I have a more nuanced point. If we begin with section 5.2 and paragraph 82, we say that reading paragraph 82, it's clear that the judge considered the sign was descriptive. We say it follows that he thought it did not have any inherent distinctive character. It's in that context that I have cited the Court of Justice's judgment in the F1 case, which is at tab 4 in Authorities Bundle 1, page 36. This is a decision in relation to an appeal from the General Court. The underlying issue is an opposition brought by Formula One licensing, and the sign applied for can be seen at the top of page 38 in the bundle. The earlier mark relied on, or marks, plural I should say, are set out under paragraph 11 on that same page. You see there's a word mark and a figurative mark. My lords, again, without wishing to teach you to suck eggs, the point about a word mark is it can be those words in any form. whereas the figurative mark includes the particular form in which it's expressed. The issue in the judgment that we are concerned with is to be found formulated at paragraphs 17 and 18. It's the comparison of the signs at issue and their perception by the relevant public. The General Court, acknowledging that the F1 sign in the international trademark, the F1 element in the trademark applied for are the same, first examined the role of the F1 element in the latter, in particular the issue of whether that element is dominant. My Lord may recall I said there are some circumstances in which you can pull out some elements and not others. The test for that is, part of the test for that is whether they're dominant. The General Court, on the basis of the evidence before it, considered in paragraphs 43 and 44 of the judgment under appeal that the term Formula One is used to designate in generic terms the sport of motor racing, and that the abbreviation F1 is just as generic as the term Formula One. Then, at 20, this is said to be the basis on which there was no likelihood of confusion, and it is that conclusion that was appealed. You see the basis for the appeal set out at paragraph 28 on page 40. The particular issue with which we are concerned is then addressed, and the findings of the court begin at paragraph 37 on page 41. What I point to is the passage at paragraph 41. And what's being explained here is that it can be a challenge to the validity of a mark, that it isn't appropriate as a trademark because it is descriptive or generic, that you see that being explained above. And what they're explaining at 41 is that where there is no such challenge, it follows that it must be treated as not falling to that validity issue, and therefore not as being purely descriptive or generic, because that is equivalent to denying its distinctive character. Now, the consequence is that set out over the page at 47, and my strong point is that the way one should read paragraph 82 is as committing this error, namely as treating the mark as having no distinctiveness inherently. And we say that that is in fact confirmed by the stance taken in paragraph 85 of the judgment, where the judge rejects the idea that it has a highly distinctive character such that there is a greater likelihood of confusion. Now, my learned friends pick up on the word highly distinctive character, or words highly distinctive character, and say what the judge is saying here is that there is an inherent distinctive character, just not at a high level. In other words, they say my strong point about the effect of 82 and the F1 judgment is shown to go too far by what's said at 85. I don't accept that in the light of the way it's put at 82, and I don't accept that in the light of the way that the judge has handled the whole issue of descriptiveness within this context. But assume I am wrong, and that my learned friend is right to say that my strong point doesn't succeed. Nonetheless, you can see, my lords, that the conclusion being reached here is without any consideration at this point of the use that had been made of the sign as at the 21st of October 2020. Now, when one has to consider distinctive character, there are two aspects to it. Again, I may have once again assumed a specialist knowledge. There is both the inherent distinctive character, which we've been touching on here, and that which is acquired through use by recognition of the public. And what we say is telling is that that analysis of the second aspect, the acquired distinctive character, is not to be found in this section. That is surprising, my lords, not least because my client had specifically relied on acquired enhanced distinctive character in relation to section 5.2. Again, perhaps for completeness, my lord, I can just take you to the supplemental bundle. And here, again, you're in the claimant's closing submissions. They are addressing an anticipated argument about the elusive qualities of Shaw. And one of the points that's being made...
Which page?
Sorry, page 194 in the supplemental bundle, paragraph 126. And at 126A, I hope my lord will accept that this is, we're in the section dealing with 5.2 invalidity, but to make that good, it's page 188. We haven't got to 10.2 yet. You can tell that because 126A says, first, you've got to accept that there is a minimum degree of distinctive character that's inherent, but you've also, they're saying, should take into account enhanced distinctive character, and they say we're going to deal with that more under section 10.2. But they are absolutely and expressly saying you ought to deal with it here under section 5.2 as well. It's part of the analysis. It's not to be found in this section. So the answer must be to say that, without mentioning he's done so, without it apparently forming any part of his express analysis, what he's in fact done is imported back into this section the later conclusion that he comes to that there is no acquired distinctiveness that he reaches when he deals with section 10.2. Again, my lords, you're making a guess there. What you can say for certain is that there is no express reference to that issue in that section, and we say that is an error.
Can I just go back to understand the significance of your, as you say, strong point?
Yes, ma'am.
It's said on behalf of the respondents, well, the judge wasn't saying there was no distinctive character. And obviously, if they're right, then the strong point falls away.
Yes.
Suppose you're right in your strong point. Where does that take you?
It would be of the same nature in its error as the failure to consider acquired distinctive character. He wouldn't have completed the required analysis because, as we're told, the assessment of the likelihood of confusion is a global analysis. You take into account various different factors, similarity of the signs, similarity of the services, but also you can get a following wind, and it is a following wind rather than a thing that can do it for you on its own, from either the inherent or the acquired distinctiveness of the sign.
And just to be clear, thinking forward, those circumstances you'd say, well, the judge has gone wrong in his evaluative exercise.
He's incomplete in his evaluative exercise.
Incomplete, and therefore he's undertaken it wrongly,
Correct.
imperfectly.
Yes, ma'am.
Where would that take you?
Well, my lord, we would say that this court should do the proper process.
Yes, that's
It has all the material before it to do so. And that the correct conclusion is that all of the factors are in favour of a finding that there is a real risk of a likelihood of confusion. And we say that, my lord, without needing to rely on acquired distinctive character, but saying that if you do add that into the mix, the conclusion is even clearer.
So more generally,
Yes, ma'am.
your submissions tend to the conclusion, well, the judge's evaluative exercise is flawed, therefore this court must do it again.
That is exactly where I ask you to end up.
Your appeal is only asking that we set aside the order.
Indeed, my lord. But my learned friend in his skeleton argument has invited you to the same position that I ask you to reach, namely that you have before you all of the necessary material. One of the questions that arises sometimes is whether it's necessary to go back over the evidence in order to do that. But of course, my lords know that subject to the judge having said that you need to have evidence of actual confusion for a finding of passing off, which we say is wrong, that evidence is not necessary. In any event, you have as much before you as the judge did, in the sense that he also was presented with paper examples. But here we say part of the reason why our eyebrows are raised at the conclusion the judge has reached is that in our submission that something has gone wrong to find that these very similar marks in the context of identical services are not something where there is a real risk of a likelihood of confusion. And there we say actually part of the problem with how he's dealt with the evidence is that it's motivated reasoning on his part. He's desperately trying to find a basis for getting rid of that evidence because of the conclusion he wants to reach, rather than asking himself, where does that evidence lead us? And that's going to be the basis of my submission under ground 14. my lords, I was trying to show you how the judge had dealt with the question of recognition by the public. And I'd shown you that there's nothing in the 5.2 section, so we have to go on. And there we say the matter becomes extremely confusing. And it may be also a point at which the error of assuming a degree of specialist knowledge that I shouldn't have done manifests itself, and I will try to correct myself as I can. If I don't correct myself, I'm sure my Lord Justice Arnold will correct me. As we saw when we went through the judgment, the judge held that VETSURE did have a reputation for pet insurance. That was paragraph 93 on page 88. But he then held it didn't have an enhanced distinctive character when assessing section 10.2 infringement. And that's to be seen in the passage that began at paragraph 108 on page 90, the conclusion at 110. And when I took you to them, I hope they are still in your minds, my lords, I do ask you to recall that the part of the reason for holding that the mark, the sign in question, was not entitled to an enhanced distinctive character was that he considered the sign descriptive. And one of the points we make is that this quality of descriptiveness is not one of the factors to be taken into account when assessing if there is acquired distinctiveness. Rather, we say, the existence of an acquired distinctive character is something that can serve to mitigate descriptiveness. And I'll return to make that point good when we look at the Steel Co. authority that my learned friend has cited. But we say the assessment by the judge is incoherent for the following reasons. First, reputation of a mark as it arises under section 5.3 and 10.3, and acquired enhanced distinctive character as it arises as a factor under section 5.2 and 10.2 are different but strongly related concepts. Both are concerned with the recognition of the mark by the public as an indication of origin of the goods or services to which they apply. And that they are related is shown by the fact that the same matters of evidence support both the analysis of whether there's a reputation and the analysis of whether there's enhanced distinctive character. Second, my submission to you is that to have a reputation sufficient to found section 5.3 or 10.3 is to be assessed to have made enough use that a finding of enhanced distinctive character in respect of those services ought also to have followed. In other words, my submission to you is that there is a hierarchy, and that if you have made a founding of reputation in relation to the sign for particular services, it ought to follow that you've made a finding of enhanced distinctive character through use. Can I begin by asking you to take out the authorities bundle 1 and turn to tab 8 and a decision of the General Court. So this, again, a decision in the context of an opposition. The mark applied for can be seen at the top of page 180, and the earlier mark at the bottom of the page. The grounds of opposition were those at Article 8.1b of the regulation. My lords, I hope you'll take it from me that these are the European legislation form of our section 10.2. Now, the Opposition Division and the EU IPO Board of Appeal had both rejected the opposition, and there were a number of points made on appeal. The first issue was the comparison of the signs, but at page 183 and paragraph 45, they turned to the appeal on the likelihood of confusion. As you see over the page at 184 and at paragraph 50, the General Court begins by reciting familiar arguments as to the correct approach to be taken and concludes that the dissimilarities between the marks fairly lead to the conclusion that there is no likelihood of confusion. They go on to explain why the appellant's arguments do not sway them on this issue. And for our purposes, The crucial passages are at page 185, and the principle with which we are concerned is set out at paragraph 62. So here it's being explained that the applicant's arguments concerning the recognition of the early mark's inherent enhanced distinctiveness, it must be recalled that as it follows from the recital, the assessment of likelihood of confusion depends on numerous elements, and in particular on the public's recognition of the mark on the market in question. The more distinctive the trademark, the greater the likelihood of confusion will be, and therefore marks with highly distinctive character, either per se or because of their recognition by the public, enjoy broader protection than marks with less distinctive character. Then at paragraph 63, the General Court, we say, is express, in particular in the first sentence, the existence of a higher than normal level of distinctiveness as a result of the public's recognition of a mark on the market necessarily presupposes that at least a significant part of the relevant public is familiar with it, but not necessarily that it has a reputation within the meaning of Article 8.5 of Regulation number 207/2009. Article 8.5 is the equivalent of 10.3. And I say that the correct way to read that is as I have submitted to you, namely that a reputation sufficient to give you the protection offered by Article 8.5 has a higher threshold than the requirement for a finding of enhanced distinctive character. That's why they're saying you can have one without the other. And I say that's a hierarchy that makes sense. Reputation of the kind being discussed here is a prerequisite for a special form of protection not afforded to every trademark, including all those that are entitled to protection under Section 10.2. As the Court of Justice explained in the Davidoff case, paragraph 19, Section 10.3 is offering a stronger form of protection to marks with a reputation. And indeed, one of the forms of damage that is contemplated under Section 10.3 is damage to the distinctive character and repute of the sign. We say necessarily, therefore, a finding that there is a distinctive character and repute worthy of the special protection offered by 10.3 indicates a level of recognition by the public that is material to the assessment under Section 10.2. And it doesn't make sense to hold that there has been simultaneously sufficient use and public recognition that one ought to consider Section 5.3, but at the same time hold that there is no enhanced distinctive character for the same services under Section 10.2. Now, my learned friends in their skeleton cite two cases in rebuttal. The first, my lords, is another judgment with which my Lord Lord Justice Arnold will be very familiar. The W3 case is at tab 5. Now, two paragraphs are drawn to the court's attention by my learned friends. The first is the one at paragraph 48 of their skeleton, and it's to be found at page 123 in the bundle. They reference it for the sentence at the beginning of 291 that reputation of a trademark is not a particularly onerous requirement. In fact, I think my Lord Justice Arnold is himself there, not quoting from, but reflecting what had been said in European cases. My Lord then goes on to cite a key case, General Motors and Eplon. Can I draw your attention to what was said in that case about the nature of reputation? So here, I should just to be clear, we're talking about reputation as it would arise in 5.3 cases, 10.3 cases, As you see at 27, the factors that you look at to take into consideration in assessing if there is a reputation are things such as the market share, the intensity, the geographical extent, the duration of the use, the size of the investment in promoting it. I ask you if you can to hold those in your mind, because I will say that they are the same factors that you are then asked to look at for enhanced distinctive character. The test is the one set out at 26. It's reached if the earlier mark is known by a significant part of the public concerned by the products or services covered by that trademark. And we say that the judge has ruled in his finding that there is such a reputation, that the evidence before him shows that a significant part of the public concerned with pet insurance knows of VETSURE as an indication of the origin of those services. That can be the only basis on which he has reached that conclusion. Now, this is a lengthy judgment, my lords. We say because trademark cases often require descent into a level of detail which...
Well, only if they present 44 issues as is identified in paragraph 1 of this judgment as to why it's so long.
I'm really just raising that to guard myself against the possibility that in rereading this excellent judgment, I may have jumped over an important paragraph. The reason I say that is that in this particular case, among the many issues that my Lord Justice Arnold dealt with, was both reputation, as you see being discussed here, but also questions of acquired distinctive character. And in part, they arose because there was a challenge to the validity of the easy marks, and one defence that can be raised is to say, well, actually, we accept that the mark is descriptive, but such is the use we've made of it that it has now acquired a distinctive character. And again, it's a different concept, but we say strongly related because, again, it's asking what is the public recognition of the mark. And the passage that I wanted to take you to is to be found at paragraph 304 of the judgment. And the reason for my caveat will become apparent, as my Lord Justice Arnold says at the beginning of paragraph 304, for the reasons given above. And I hope that I have found the paragraph that my Lord is referring to there, but I want to accept the possibility that I haven't. Could I just ask you to read paragraph 304? It's quite brief.
Yes.
Now, what I'm interested in that paragraph is the decision about the status of EasyJet, where my Lord Justice Arnold was prepared to accept that EasyJet had acquired a greater degree of distinctive character than it inherently had in relation to temporary accommodation by June 2009, but was not satisfied that EasyJet had a reputation in relation to those services as at June 2009. And I take that to be an indication that the hierarchy I suggest exists is being reflected in that decision. The question arises, what did my Lord mean by, for the reasons I've given above? And I think my Lord is referring to what he said at paragraph 181 on page 99.
Sorry, I wasn't keeping up again.
No, it's quite right, my Lord. Page 99, paragraph 181, factual finding. It's in a different context, which is why I'm nervous that I haven't got the right precursor reference, but this is where the discussion of the use in relation to temporary accommodation, my Lord Justice Arnold had found that that hadn't happened at an earlier date, 2000. I think my Lord is holding that by this stage there have been such use. For completeness, my Lord, I ought to show you paragraph 238 as well. And now we're in a part of the judgment that is dealing with infringement under Article 9.1b, so the equivalent of 10.2. And my Lord, Lord Justice Arnold has set out various principles of law. And then at 238 is looking at the question of enhanced distinctive character. And if you see halfway down, in the case of EasyJet, there is discussion of acquired distinctive character. But it's a different date to the one that's being dealt with later on. So I don't understand that to be the reason that my Lord is giving when he says for the reasons given above. I took it to be the discussion of the use that had been made in relation to temporary accommodation by 2009, and that's why I pointed you to 181. I freely hold my hands up, my Lord. I've done the kind of searches you might wish to do, June 2009, so on and so forth. If I have erred, my Lord, it's not for want of trying. I believe I found the right paragraph. In a sense, one can go to the forms at Origo of the decision to know.
If indeed he has a better recollection of all this, then
I don't think I should take too much time over it, because, my Lord, all I'm saying is it's consistent with. I certainly don't rely on W3 for the proposition that I advance before you. I simply say that my learned friend is wrong to suggest that it is against it indeed. If anything, it shows you my Lord is accepting and using the hierarchy I'm talking about. The other decision they point you to is Steel Co., and that is in the authorities bundle at tab 1. Sorry, tab 3, I apologise. Page 20. This is an appeal to the appointed person. Now we're in the UK's IPO. It's in an opposition to the application to register Steel Co., among other things, office furniture, that had been opposed by an earlier mark for Steel Case, registered for, among other things, chairs. Now the paragraphs that my learned friend points to is paragraph 17 on page 31, but I ought to contextualise it by asking you to look first, please, at paragraph 8 on page 24. So here there, Mr. Kitchen, KC as he then was, is setting out a passage from a judgment of Mr. Simon Thorley, Queen's Counsel, as appointed person, in which he has held, Mr. Thorley, that what we're looking for is something of a household name, so that the propensity of the public to associate other less similar marks with that mark could be enhanced.
Yeah, well, that's referring back to an early debate and the history of the European legislation as to whether this was protection for well-known marks or whether it was protection for something less than that. The result was it's not well-known marks, it goes beyond that.
My Lord anticipates, and again, if my Lord will Justice Arnold will forgive me, I'm perhaps taking this more slowly than I need to, but at paragraph 27, you can see that debate was still happening in the Steel Co. case.
Sorry, paragraph
13 on page 27.
Yeah.
And so then that issue is being considered by Mr. Kitchen at paragraph 17. Again, he's explaining the general principles, and he, in the middle of paragraph 17, says, as my Lord Justice Arnold has indicated, duodebs is not right, or should be qualified, I think is probably the better way of putting it. But for my purposes, and for the purposes of the debate before you today, the paragraph as a whole is no contradiction of my submission to you that where you have a reputation, you have an enhanced distinctive character, because the recognition of reputation is a recognition that the significance of the sign as an indication of origin is known to consumers. Indeed, I go further than that. What's said towards the end of this passage is in fact grist to my mill when I say that the judge did not disentangle the various issues, because here Mr. Kitchen is saying that a mark's reputation, its acquired distinctiveness, may serve to balance out, to counterbalance rather, a low inherent distinctiveness, as he had found, or not to have the possibility of confusion dismissed on the basis of descriptive connotations. So you see, in the case of marks which are descriptive, the average consumer will expect others to use similar descriptive marks, thus be alert for details which would differentiate one mark from another. Where a mark has become more distinctive through use, then, this may cease to be such an important consideration, but all must depend upon the circumstances of the particular case. And we say that is a reminder of the significance of the absence of any discussion of reputation or required distinctiveness in the context of section 5.2, an indication of an error on the judge's reasoning, which appears to have turned on the assessment of inherent distinctiveness alone. And we also say that when the judge rules against distinctiveness through use on the basis of descriptiveness, he's mixing two separate issues, because it's clear that use is a factor that counts against descriptiveness. So we say neither of these authorities that my learned friend cite are contrary to our argument. In fact, they're consistent with it. And my learned friend makes two other points. Perhaps my lords can put away that authorities bundle for a moment. And we're in my learned friend's skeleton argument at paragraph 53, which you will find in the core bundle at page 49. And the criticism that's made there is that we are said to be wrong to suggest that the judge didn't take into account distinctive use. And in response to that, we make two observations. The first is that the references that my learned friends give in that paragraph are all to passages in the context of section 10.2. As you know, we say the silence that is to be found is in the context of section 5.2. No discussion of the effect of acquired distinctiveness there, even though the point has been raised. But the second is that really, in this paragraph, they're missing the point that I am trying to make in my skeleton argument, which is the one from Mr. Cabot, KC, and Musmatch, namely that the impact of descriptiveness on the likelihood of confusion is reduced when one considers that the defendant's sign is being used not descriptively, but as an indication of origin. I've made that point in detail. The next point to address is that at 55, they say they're picking up on a point that we'd made, that one of the findings was that sure was used as a suffix for insurance, but only by my client in the particular context of pet insurance with which the court was concerned. And they say that doesn't matter if the only user in the pet insurance market is my client. Consumers understand that the suffix sure indicates insurance generally. But our response is that that observation is no answer at all to the question of how distinctive through use VETSURE is within the particular market with which we're concerned, namely pet insurance, and that's the point that I'm trying to make at paragraph 12 of my appeal skeleton. Now, my lords, I've managed to cover all that I wanted to say on grounds 1 to 3 and much of ground 4. In doing so, you'll appreciate I've also covered the grounds that address infringement under section 10.2 also. There is one brief point further to make on ground 4, and that's about indirect confusion. And I deal with that briefly because my lords will have gathered both at first instance and here on appeal before you. Our primary allegation is that there is a real likelihood of direct confusion once one appreciates the degree of conceptual similarity in the context of imperfect recollection and the fact that all the factors point in favour of that finding. We do, however, say that there's a real likelihood of indirect confusion in the absence of direct confusion. That's a scenario that arises on what the judge seems to think will always happen, namely that the consumer sees PETSURE and perfectly recalls R mark VETSURE so as to be conscious of the V and P difference. And one of the points that's put against me by my learned friends, paragraph 93, is to say, well, that's inconsistent with our case on direct confusion, where we say that the V and P will not always be noted or recalled. It isn't, my lords. It isn't, as I explain in paragraph 18. What we're doing here is addressing the alternative to what we say is the correct position. the alternative that the judge seems to have taken to apply, and which we say doesn't reflect a requirement for imperfect recollection. And so I'm looking at that scenario in the alternative. And in that scenario, consideration should have been given to how the V versus P distinction would have been processed by the average consumer who notes it. And we say that it's likely a substantial number of consumers noting that the signs are, in all other respects, identical, that the services are identical, knowing of the reputation of VETSURE for pet insurance sold through a network of vets, will think that this is the version of that pet insurance that is made available not through the network, but direct to consumers via the internet, for example. That's because the change from V to P we submit is an obvious extension of the existing brand in the context of identical services, but where one version of those services is coming through one route to market, namely vet clinics, and the other is coming direct via online sales. Now in this context, the real issue is, again, the error lying in a failure to address indirect confusion at all in the judgment, because it meant that the judge did not consider the point that was made by Lord Justice Arnold in the Musmatch case, namely that indirect confusion is inherently less likely to come to light than direct confusion. Now, my learned friends suggest in their skeleton that the judge did, in fact, deal with indirect confusion. You can see that in what he said at paragraphs 86 and 112. Can I ask you to turn up those two paragraphs? First, 86, which is to be found on page 87. And then 112, which is to be found on page 91. In both cases, the judge is referencing the issue of the network of vets, but that wasn't a point advanced on indirect confusion, but on direct confusion. And again, you can see that in the claimant's closing submissions, in the in the supplemental bundle at paragraph 171 on page 204 in that supplemental bundle.
Sorry, which paragraph?
171.
171. Yeah.
The learned friend is whispering that it is a typo. I don't accept that it is. Certainly the judge hasn't taken it that way. My learned friend has an argument, his skeleton argument here, that the argument we make on indirect confusion was not advanced below. It's specifically directed towards the appeal of towards the example of how indirect confusion might arise. It's given in the skeleton argument at paragraph 13. That, my lord, is to ignore the gravamen of the complaint, which is that no consideration is given by the judge to this question at all. As the defendants accept, indirect confusion was pleaded. I can give you a reference, I don't need to take you to it. It's in the supplemental bundle at tab 1, page 7, in response to question 5 of the defendant's RFI. And you can also see that it was argued, I don't care to do so, again I don't suggest I need to take you to it now. It's at page 53 of the supplemental bundle in the transcript. Indirect confusion by way of brand extension is referred to by a counsel below. It's the point made on appeal. It's expressly addressed at page 23 of the transcript, over to the top of page 24 of the transcript. But what you can see, my lords, is that despite being pleaded, despite being referred to in all submissions, there's no discussion of it at all in the judgment. Now, it's correct to say that the manifestation of indirect confusion was not expressed to the judge below in precisely the way I've advanced in the skeleton on appeal. We don't say thereby the issue of whether or not the judge should have dealt with indirect confusion is thereby precluded from consideration. It was a pleaded issue, it was an issue before the judge, and more than that, it's an issue that we say arose particularly on his assessment that consumers will always note the difference in the first letters. And the proposition that it be seen as a brand extension, which is all that I advance as my basis of my argument, was part of the contemplation of the judge, and indeed he even cites those passages in the authorities on which we rely for the argument we make. In any event, we say it's an argument the defendants have had an opportunity to respond to. They suggest the case might have been run differently below, but indirect confusion was run below. One of our complaints is it wasn't addressed properly below. There's also a suggestion that new evidence would have been needed. They say it, but they don't say what it would have been. Well, there was already evidence before the court as to the different routes to market of the two parties, as to the understanding of consumers as to what they were obtaining. The absence of specificity in my learned friend's skeleton is just a reflection of the fact that this claim to need new evidence is assertion, no more. If that were so, then the test that is set out in the Rheinmetall case, which I've added into the authorities, we say is met. But in any event, my lords, we say that the gravamen of the complaint is not touched upon by the particular example that they complain about.
So just to be clear, you say, well, you're entitled to run the point.
Yes.
And you say the judge didn't consider it.
Yes.
That leads back again to you saying, well, this court should make up its own mind.
Yes, ma'am.
So why should the court, making up its own mind on that hypothesis, decide that there is a danger of indirect confusion?
My lord, because once you've done the analysis, as it should be done, considering all of the issues of imperfect recollection, if you still conclude that there will be no direct confusion, we say that there will be indirect confusion, and it will arise because even those that are aware that VETSURE and PETSURE are different, given the conceptual connection, will be led to believe that this is a brand extension that deals with one of the different routes to market that VETSURE already provides.
I mean, just talking off the top of my head, it seems to be unlikely you'd use a different name for a different route to market, does it, or not?
Well, you say that, my lord, but there were sub-brands. For example, the pet health plans had a different referent, and indeed in the market, different types of insurance might well be referred to by some a different aspect of the way in which parties obtain them. And in this particular context, the network issue is relevant because if you're obtaining the insurance via your vet, then you might understand that the vet reference is in some way connected to that, the route to market. Whereas if you're obtaining it through the online route, then you might think that that's the reason why you're dealing with the PETSURE aspect here, because it doesn't contain that network element.
I mean, I can see why you might use a different name for a different product, but I can't quite see why you'd use a different name for a different route to market, when indeed you might want consumers to associate this new route to market with the previous route to market.
You might well do. You might well do, but that's why it would be a brand extension. They know about the vet network and VETSURE. Now they think, oh, I found it online. It's the same people because it's basically the same sign. But I've noted there's a difference. Why is that there? Even though it's the identical services? Because I'm getting it online, not via my vet.
The indirect confusion, I thought, far more likely to occur with pet plan than with vet insure.
I disagree, my lord, because what pet plan and VETSURE and PETSURE, pet plan doesn't have the all the extra elements PETSURE that we find with VETSURE. You've got something that you already know and recognise. Now there's just a tiny variant, whereas with pet plan you've shifted to a different frame of reference altogether. I'm not saying you wouldn't necessarily be confused with them. I'm just saying it's my lord's suspicion you'd be just as likely to is not right. But my lords understand that.
That's not your primary case.
My primary case is direct confusion. And really I draw it to your attention because I say, again, what it symbolises is a lack of rigour on the part of the judge. Maybe understandably frustrated that he hadn't been given enough help by the parties, but nonetheless, unfortunate. It should have been dealt with and it wasn't. My lords, passing off, one question that will be asked of me is what can this add to what I've already said? And certainly we say before you, as we said at first instance, that on the underlying question of whether there's a clash between my client's VETSURE sign for pet insurance and the defendant's use of PETSURE for identical services, judgment should have gone the same way for both trademark infringement and passing off. so that on appeal, passing off adds only this, that my lords might judge that I have failed clearly to establish an error of principle in relation to the trademark infringement aspects that permitted you to reopen the judgment under that heading, but nevertheless conclude that I had managed to do so in the assessment of passing off. And on that basis, let me focus on what we say are the errors unique to the passing off heading. As my lords will have seen, that was dealt with briefly at pages 102 and 103 of the core bundle and paragraphs 186 to 191, which I took you to when I began. The point that I draw closest attention to is the suggestion that an absence of evidence of confusion or deception is fatal to a claim in passing off. We say that's simply wrong as a statement of the law. The position in trademark infringement and passing off is the same. In neither case is evidence of confusion or its absence essential to the finding. Can I ask you to take the bundle up just to see that it isn't an infelicitous statement. It's a deliberate identification of what is needed in the context of passing off. Because having said that it was fatal to a claim for passing off, earlier at paragraph 113, when beginning to address the evidence of actual confusion and in the context of trademark infringement, using similar terminology, he had stated, I note that evidence of actual confusion is not necessarily fatal to a claim for infringement. And we say that that allows you to conclude that he considers there is a difference between trademark infringement and passing off, and the difference is that it is fatal in the context of passing off. Now, my lords know we submit there are further errors. Those might be more debatable if they didn't come in the context of this central error of assuming there needed to be evidence. But if you look now at page 89, you have section 5.4, which is dealing with validity under the question of passing off. The key paragraph is 103. It is conclusory, but we say even in its shortness, it reveals error in its final sentence. At first, we say the judge has not addressed the different target consumers. He's no longer concerned with consumers at large, but with those consumers with whom the claimant has goodwill. The difficulty here is that we say he's failed to give due consideration to the effect on consumers with whom the claimant has a reputation. Well, the point applies redoubled in the context of passing off, because it is those consumers for whom VETSURE means the claimant with whom we're concerned, and yet the judge is looking at a broader pool and asking if a substantial proportion of that broader pool are deceived. Well, not just deceived, apparently confused and deceived. Again, we say that reveals error because confusion and deception are not the same thing, and deception is the touchstone of passing off. What does the judge mean by saying not confusion and deception? We don't know. But given that he considers the absence of evidence of confusion to be fatal to a passing off claim, we say the confusion, if I may use that word advisedly, that is manifest in this final sentence suggests that he is not engaging adequately with the issues raised in a passing off claim, and that the whole sentence is consistent with the judge applying a test suitable for trademark infringement to passing off. And also I come to the last part of my submissions to you, which is ground 14. It is the last that I deal with, but we say not the least of the errors that manifest themselves in the judgment. It's sensible to deal with it last because the discussion of the judgment that precedes has framed the points I want to make. The overarching objection is that the judge's analysis shows motivated reasoning. He's decided that there is no likelihood of confusion and now approaches the evidence, interpreting it to confirm that proposition, and we say that the evidence should have been used as a check on his reasoning. We make two specific points, they are connected. The first point is that the judge has looked at the evidence of actual confusion and treated it quantitatively, asking effectively, is there enough evidence of actual confusion here? We say that's the wrong approach to such evidence in general, and wrong on the specifics of this case, where he could not be confident that he had seen all that there might be. The second point is related to the first, in that we say he erred in looking at the evidence as if its only relevance was whether it indicated actual confusion in these witnesses. What he should have done in our submission is used as a check on the very propositions that he had adopted as leading to the conclusion that there was no likelihood of confusion. What do we say those propositions were? For the purposes of this submission to you, my lord, we say this. The judge had taken it as read that the consumer perfectly recalled that there was VETSURE and a PETSURE, and in other words, was always keeping in mind the difference in the first letter. That consumers understood there to be a conceptual difference between the signs, and that this was allowing them to keep them separate in his head. And it is in the light of those two propositions that the evidence should have been used, but when it is, it becomes clear consumers are not keeping alive the difference between V and P in their minds. In fact, they're struggling to recall it. Certainly none of them are correctly identifying the two as distinct because they're thinking, a vet and a pet are different things. Indeed, my lord, we say the correct approach is the one that my lord, Lord Justice Arnold, set out at paragraph 120 of Lidl and Tesco in the Court of Appeal at the beginning of this year. It's a passage that is cited by my learned friends in their skeleton, and it can be found at page 51 of the core bundle. Perhaps I might ask you very briefly to read it.
Sorry.
It's page 51 in the core bundle,
Yes.
and we're in a passage from the judgment
From
of Lidl and
Lidl.
Tesco. It's paragraph 120 that I
It's
asked you to...
121.
Yes, I apologise. My lords, for the purpose of my submissions over the next few minutes, it would be helpful to have two bundles open before you. The judgment, in particular, that part starting at page 92, and the supplemental bundle, and the final tab of that bundle, which is a few samples of the confusion evidence to which the judge refers. I'm just going to take a few examples of what was considered by the judge plainly. My purpose on appeal is not to ask you to reassess the approach to the evidence, but to make good what I say with those two errors. The failure to do what is set out in paragraph 120 of the Lidl. The first example dealt with by the judge is at paragraph 120 to 122. And here the judge is saying that the caller understands who she is calling and is able to distinguish between the parties. But my lord, we say, even in the section we see quoted in paragraph 120, she is not in fact certain. More importantly, you can see she is not relying on the V versus P difference as conclusive, and nor does she consider that the two are distinguished by any form of conceptual difference. The full transcript, my lords, is in that supplemental bundle, and it is behind tab 13 at page 300. But the telling section, we say, is over the page at 301. And there you see the lady in question ask, okay, can I just check that you're definitely VETSURE, not PETSURE? No, we're definitely VETSURE. There is a company called PETSURE, but that's not us. I know, I'm getting so confused because I got an email from PETSURE and I thought, oh gosh, so I'll look for VETSURE. Okay, brilliant. Now we would accept that this is not evidence of confusion as such, but it is, we say, a good test of the judge's propositions, and it is contrary to those propositions. back in the judgment at 122, the judge says of this example that staff at PETSURE sometimes mentioned the claimant to callers who were uncertain or mistaken in their calls. My lord, it cannot be that. This example is a call to the claimant. It has nothing to do with staff at PETSURE. Now, at best, my lord, therefore this statement is an example of a lack of care in consideration of this evidence, but at worst, we would say it appears that the judge has confused the two parties at this point. Next, at 123, an example is dismissed as being simply misnaming. But again, we say that the question it should have raised with the judge is whether his propositions were sound. And again, we say it is in fact inconsistent with that being the case. My lords again could see the transcript at page 302 in the bundle. I should point out, my lords, at 303 where the transcript goes on, the call is ended because the lady says she's having difficulty hearing, there's noise at her end. But if we turn back to 302, no suggestion by at this point that she can't hear. What is clear, we say, from looking at this, is that the VETSURE telephone operator immediately says that she is from VETSURE Pet Insurance. But despite that, the receiver of the call is not immediately prevented from thinking of PETSURE. Certainly doesn't go, oh, at any stage conceptually different. None of them, crucially, are saying that they thought these signs were anything other than identifiers of origin. In other words, they're not being treated simply as descriptions of the services in question and thus elided on that basis. So that although, again, we can accept it's not evidence of actual confusion, as to the question of the likelihood of confusion, it is, we say, probative of the judge's assumptions and cuts across them. Now, my lord, the same points may be made for the other examples. We've not put in all the underlying material in the supplemental bundle because our point is about an error of approach, not a suggestion that we should reopen the particular findings of the judge from start to finish. And they are to the same effect. The judge dismisses them as if they are not indicative of actual confusion, even though they ought to have been considered as a check on his analysis, paragraph 120 of Little. We do go further. In some cases, we say it's not clear what the judge actually means by dismissing the evidence. So back in the judgment at 133, we're referring to the social media post here. And he says it's not clear if this was an instance of confusion or a naming error. The post in question, my lords, can be seen at 309 in the supplemental bundle. And the image is crystal clear, but the wording above nonetheless refers to PETSURE. The lords must appreciate, of course, printed out in a bundle at court isn't how a party would have appreciated, so I take that on board. But it doesn't matter, we say, whether this is actual confusion or a naming error. What it's showing is that people are not distinguishing PETSURE from VETSURE on the basis of the initial letter and a conceptual message of difference that they convey. Similarly, we say other cases where the judge is simply too swift to dismiss matters. If you look at paragraph 136, we have a collection of invoices, claim form and emails relating to a claim made on VETSURE from BT.
Your pardon, can you give me the reference?
I do apologise. Page 95 in the bundle.
Yeah.
Paragraph 136.
Yeah.
The 14th. And perhaps, my lords, you just quickly read that paragraph, it's very short. What the judge is referring to here is to be found at 313 of the supplemental bundle. this is the claim form. I'll just pause there. The judge, in the judgment of paragraph 131, suggests that the claim forms are similar and it's easy to mistake one for the other. He's referring there to the body of the claim form. The question he ought to be asking is, why is it easy to do so given that the word VETSURE is so prominent at the top of one? My lords, I can tell you that PETSURE appears in the same place on the other, in the same size. We say that ought to have rung alarm bells, that such a prominent reference is not allowing customers to distinguish between the two. Certainly, it ought to have challenged him on the question of why or whether they are noticing the differences he says they would notice. But in this particular case, you can see that the customer has filled in their policy number, and it's a PETSURE policy number. The vet has then emailed it to VETSURE claims. And so in the usual way, my lord has to sort of go backwards through the tab. And what you see is, on page 3112, please find the attached documents requested for us to submit a claim, Chase Too Good. Excuse me, I shouldn't have said that probably out loud. Policy number PSR. VETSURE claims responds saying, I look at the reference, this doesn't seem to be a policy holder of ours. I've searched the system, I cannot find the policy. Can you confirm that they are a VETSURE customer? And the receptionist replies, the client has a policy with PETSURE according to the policy documents. So at this point, she's conscious that it's PETSURE. If this is the incorrect claim form or the correct claim form, but unable to locate the policy. So she's been asked what's gone wrong. She knows that it's PETSURE. The email address she's emailing is claims@vetsure.com. But at no point does she go, oh, V versus P. Oh, they're conceptually entirely different. There's no way oops. The judge says there's no explanation for how this error arose. Would we say, neither customer when filling in the form, nor receptionist when passing it on, has noted that VETSURE is not PETSURE, even though they're making a claim for money in respect to it. The answer for where the error lies is obvious and is the one that is given in reply by the claims assessor at the top. They are confused between VETSURE and PETSURE because of the similarity of the names and the context of the identity of the services. There's no, to use the phrase of Mr. Kitchen in the Steel case, there is nothing here or in any of the evidence to suggest that the descriptive connotations of the sign are making the consumers alert to small differences between the signs. Back in the judgment at paragraph 141, there is another example. It's simply a description in the judgment of what has happened. So we must take it to be swept up in the judge's general complaint that these are mistakes. But again, we say the judge is too quick to dismiss it on the basis that it is not clearly evidence of actual confusion. The point again is that the initial letter is not noted, it's not serving to distinguish either visually or conceptually so as to prevent confusion. Now, if you look at that one, which is at page 317, the relevant discussion is at the bottom of 317 over to 318. And the reason I draw it to your attention is that yes, sorry, I'll give you, my lords, a moment to look at it. Yes, here the confusion has been clarified in the context of a call expressly saying, there's an error, can we work out where the error arises? But what you can see is that the matters the judge has held to distinguish are not serving to do so. Similarly, at 142, the judge dismisses an example on the basis that it is not clear that the caller was confused. We say that's surprising. She clearly was confused. It's just that the confusion is then cleared up. This one is at 325 in the supplemental bundle. Again, right at the outset, the caller is told you're speaking to VETSURE. That doesn't disabuse her. It's only after the customer has to give the policy number and is told that there is no record of her with VETSURE that she is prompted to look again. The name is not serving to alert her. And the examples from the defendant's disclosure are all to similar effect. Even when the person in question is in the presence of the correct sign, they are not noting the differences so as to avoid falling into error. And again, the judge is willing to dismiss the evidence as not showing confusion if it is cleared up. And may I take this as my last example? At 150.
It's also quite interesting what the caller says just below the second hole punch. It's the shore that got me going.
Grist to my mill, my lord. 152, my lord, in the judgment. Now we're into the defendant's examples. The third is an email from BP to PETSURE asking for information about VETSURE's pet health plan. Customer has seen information, possibly a poster at a vet's practice that said pet plan in large letters at the top, VETSURE in smaller letters at the bottom. The customer mistakenly contacted PETSURE. They do not appear to be confused. Well, my lords, if you take this up at 328 in the bundle, again, it's one of those ones where you have to work from the back to see what's happened. It's described as an email. I think what we have initially are communications through a kind of chat program. At any rate, they're either attached to an email or they may be an email, but I mention it because it's not in your standard email format. But at any rate, BP has got in touch with PETSURE. You can see he's done it via a website, petsure.com, and he gets a response from PETSURE support. So it's the PETSURE support team. So PETSURE is everywhere. And he writes to her and says, look, I'm trying to get the pet health plan. I've attached a photo from our vets. And if my lord looks at the photo, it's got VETSURE in the bottom left-hand corner. Now, it might be that in this photograph, that's quite small, but the man has taken a photograph of it. How has he got to contacting Lucy in the first place? There's only one explanation. He's got confused because of the word VETSURE, despite it being so prominent. That's not a mistake. Or if it is a mistake, the question is, how did the mistake arise? Again, even if you don't take this as evidence of confusion, or even of confusion that's been corrected, you ought to consider whether it is evidence that shows your assumptions about the role that V versus P is playing in preventing confusion, conceptual distinction, whether they are functioning the way you think they are. But the judge dismisses all of this at paragraph 167 of the judgment as administrative errors of the kind found in the European. In fact, my lords, we think he gives in that paragraph a reference to the Court of Appeal judgment. It does give a reference to the Court of Appeal judgment. He must mean the first instance judgment because that's the one that discusses the 3 calls to the offices of the European. All of those were people calling the European, asking for the European voice. They're told, no, this is the European. They go, oh, I didn't want that. These aren't examples of that kind. The errors, if errors they are sustained even after the correct name is identified. They lead to the problem in the first place. Even when the judge is willing to acknowledge confusion exists, as with the example he deals with at paragraph 165, he doesn't extrapolate from that to the testing of any of his propositions. The example at D16 that he's referring to at 165 involves a customer who had bought the wrong company's insurance, then realised it or had it brought to her attention, perhaps because her vet, who she says is linked to VETSURE, alerted her to the mistake and had to cancel it. There is no curiosity by the judge as to how that situation has arisen or how widely it might be replicated in instances where the customer hasn't realised it. It hasn't come to the party's attention. Instead, the judge observes that there is confusion. He dismisses it on a quantity basis. 170, he says, a small number of instances. Or we say that's motivated reasoning. The question he should have been asking is, why are there any instances at all given his earlier assessment of the consumer's understanding of the marks. It's not just that it's notoriously difficult to obtain confusion evidence. It's not just that we say there was a big gap in the disclosure here because the defendants had searched their own records, but not the records of their core claims handlers, the obvious point of contact with consumers. It's also because, as my lord, the judge had noted himself at paragraph 59, the parties were small players in the market for pet insurance. And we say that should have indicated something to him, namely, that the presence of any cross-confection of this kind was not simply the result of the ubiquity of either player in the market. These were two relatively small ships in a vast ocean, and yet instance after instance of them crashing into each other. In the end, my lords, we say this appeal is straightforward. The judge heard early in his comparison of the signs. He did so in a classic manner, broke them down to pass them, he neglected to reassemble them, to consider them as a whole. And indeed, my learned friends seem to recognise in their skeleton that the judge's approach to the conceptual message is flawed, because they seek instead to emphasise this issue of descriptiveness. We say ultimately, for the reasons I've given, that doesn't help them. The issue does need to be understood in the context of distinctive signs being used to indicate origin, visually, orally, and, by submission to you, conceptually similar in relation to identical services where the earlier mark had an unchallenged reputation for precisely those services. A finding that there was a real risk of a likelihood of confusion was the right answer, and the evidence in this case is entirely consistent with that answer. The appeal should be allowed, and we invite my lord to impose their own view, I say, in the lines that we have put forward. It is indeed, I think, the only point of agreement between myself and my learned friends. As they say at 95, there's no need to remit matters, we agree. The correct course of action is to form a comparison of marks and emerges from agreed matters. And the result is a respondent's mark invalid under 5.2, use of the sign infringing under 10.2, passing off and 5.4 go the same way. My lords, I've talked out my time. Unless my lords have any questions, I'll just check behind me. I may turn my back.
No, I don't detect any. Thank you very much, Mr. Randall. Mr. Mallon, I think we have got, whatever the clock says, 8 minutes. So it's probably worth
that's a little fast.
Making a start.
Lords, I think what I could probably do is usefully deal with ground one in the time available. It wasn't withdrawn, and but it was advanced gently and said to be not strong enough on its own. It's actually indicative of part of the sort of flawed approach overall, we say, to this appeal. There's a certain amount of tinkering with the comparison exercise that one has to go through as a sort of precursor to the important bit of analysing whether there's a likelihood of confusion. And that's really where most of the appeal has been focused. In particular, the point about conceptual similarity. But in this part of the appeal, what is said is that the judge should have held that they were highly similar. The marks were highly similar, visually and orally. And I think it's probably worth for me, just before the short adjournment, to just make a brief point about the way that these cases are decided. It normally works in the following way. You assess the similarity of the goods and services, and that comes first as a sort of threshold question. Then you do the comparison.
Common ground, they're identical in the present case.
Common ground that they're identical in the present case. Then you assess the marks, and you assess those from three perspectives: visual, oral, and conceptual. And then, and only then, do you move forward to the stage of assessing the likelihood of confusion. That brings into play the factors that you've already established, the degree of similarity between goods and services.
One out there, of course.
Reputation and so on, yes, of course. That would come in at that stage as well. But the point that I wanted to make here was it's very important these issues do not cross-contaminate. It's very important that things are not done double-counted. And it's extremely important that you don't develop any super factor that then comes and operates at every level of the case. And in my submission, that is part of the problem that's being advanced here as part of the appeal. The first of them is ground one, which is that a particular finding that there was in fact visual and oral similarity is said not to be strong enough. We want more. Can we trade in our findings on visual and oral similarity and have a high similarity for those, please? Because we want to use them later to show, in fact, there was a likelihood of confusion. And that's not the way things are done. We say, put simply, it doesn't make a difference for a start, whether it's high similarity or similarity. It's secondly a point on expression. Logically, the judge's finding of similarity includes high similarity. When it simply doesn't know the degree of similarity. Thirdly, it's a classic attack on the multifactorial evaluative exercise, which is really has no place in an appeal. And we can see that because in that section of the judgment, I won't turn it up, but before that, the judge is very carefully considering the various arguments that are put to him. We were arguing for a low degree of similarity, not none, as Lord Justice Arnold correctly surmised. And the claimant was arguing for a high similarity. The judge said similarity. So there wasn't really a finding here on which this ground can bite, but it is indicative of its approach to sort of wishing to blur some of the distinctions between these exercises that need to be carried out and when they need to be carried out. Because what happens is, I'll show you in a moment, the German, that the basic problem with the conceptual argument is that they want to bring in a different, they're not focusing purely on the comparison exercise. As a matter of pure comparison, as the meanings of words, you're not allowed to think about the goods and services at this stage, that's just been thought about, double counted. You say, what do those words mean? And I'll show you the apple and pear case. What do those devices, those figurative marks, convey? And that's the only question, because the moment you start bringing into the analysis any kind of assessment about, descriptive of these goods and services, you're already getting into a different consideration. That is the descriptiveness point, and that can be very important. It just has to wait.
I'm not sure I understand that. How can you, if you're asking yourself whether a mark is descriptive, how can you do that without knowing what it's supposed to be describing?
Lord, you don't
Take the
avoid...
famous example of soap for soap.
Yes.
That's descriptive for soap, but it's, as was often pointed out, not descriptive of bananas.
Yes. I'm not suggesting for a moment you don't take into account descriptiveness. It's simply a question of stage.
Yes, but to assess descriptiveness, it has to be descriptive of what?
You're not, but the point is this, you're not actually asking it descriptiveness at this stage. What you're saying is, what is the meaning? It is a purely abstract exercise. What is the meaning of this sign that I am looking at? That's the only point, because otherwise, the moment you start thinking, oh, that is descriptive of bananas, or soap, as the case may be, you are already either jumping backwards into the goods and services, or you're jumping forwards into the position as the likelihood of confusion. This is purely trying to assess, it's a comparison exercise. That's the really important point. Whether it's got a reputation, whether it's descriptive, none of those things are relevant to a comparison. A comparison is simply, what is that and what is that? And perhaps I'll show you after lunch with the apple and pear case. So I'll have to have a look at that in a bit more detail. That brings out the point absolutely clearly. You are not permitted, in fact there are many cases of this sort where people try and say, well, I've got a big reputation, therefore I'm more visually similar. No, your reputation simply doesn't come in at that stage. It may come in later, but you're just trying to understand, is this a pear or is this an apple? I think probably I'll hopefully explain that in a bit more detail.
So we'll break there.
Yes.
And resume at 2 o'clock.
I'm great.
All right.